over this 30 years. But interest is about 1,000 crores or something. More than that. Now, so if that is not suitably modulated, it will reduce their burden. So we are here for balancing. None of the petitioners have talked of balancing. No collection, no refund, ultra virus cases. We are here in intra virus situation. Normally, in view of Article 265, once a law is passed, nobody can say that don't collect the tax. But the lordships have got this special powers under 142 to modulate depending upon a particular situation. Otherwise, ordinarily, your lordship will never do this, not that the law is valid, but tax, don't collect the tax. But let me take, my learned friends must have calculated, I'll take them on their words, so that I can also visualize that there will be some effect, maybe cascading. So this is how it can be done. This is not, we need not adopt the ultra virus situation here and say that no collection, no refund. That's very convenient because nowhere they must have paid. The proceedings must have
come down soon after India's amendment.
Because somewhere, even where lordships have said no interim order rejected. I have an expert in my every case. Barring Odisha, Bihar and Jharkhand. In Andhra Pradesh, stay rejected. This is another vital factor. That once the stay was rejected and High Court you lost, then you should have collected, you should have passed on. If you have not passed on, then you have willingly not passed on. And the law on tax is that passing on is your discretion.
Yeah,
Not a law.
Pradesh, what happened?
No, there was no law.
There
was no demand. State-wise, we have to say many things.
Can be state-wise.
State act-wise, we have to
Talked
say
about
many things.
Mineral bearing land. Odisha is all mineral bearing. The act was shut down in 8 months. Not a single penny of demand was raised.
I don't understand.
You could not collect.
Situation, my lords. 2005, a cess was levied on minerals. My lords, while entertaining a challenge to the cess, the High Court declined to grant an interim stay. In 2007, this Honorable Court gives an interim stay on the operation of the cess. Till date, the Act continues to be on the books. Therefore, my lords, in my humble submission, Act which continues to be on the books, the question of prospectivity or retrospectivity would not arise. Only the operation has been stayed by an order of this Honorable Court.
Struck down in Andhra Pradesh.
Never. That is why we are on a factually unique footing, and I just want to point it out.
It was not struck down because now it is pending here.
Now,
My lords, yes.
Just hold on.
To say much.
Now you say much. Nobody stops.
Probably Jharkhand. Kind of like.
But you are interrupting.
That is state-wise because
State-wise, we have to say much. The architecture of every act is different.
the Andhra Pradesh did
What,
not share because
what
of
we should do is, we'll lay down broad conditionalities, that which is within our power. We'll of course reflect on it if travels. But Mr.
Just allow me to finish.
I want to say something after.
Allow me.
Let him finish.
Yes, yes, after he comes.
Let's not, 1 second, Mr. Dwivedi will finish in 2 minutes now. We let him. Yes, Mr. Dwivedi.
Now, Madhya Pradesh, Lord, High Court upholds, no stay. Rajasthan upheld, no stay. Chhattisgarh upheld, no stay. Chhattisgarh, they said you have to pay subject to the outcome.
are these laws under entry 49 or under entry 50?
So there are many things. State-wise, we have to say many things. And Madhya Pradesh and Rajasthan have taken a pro-citizen-centric approach. We do not wish to collect the past dues.
Who prevents the states not from passing a law tomorrow and saying that don't pay? It's not my argument that if your lordship says it will operate as it is, then Rajasthan is certainly free, Lord, to pass a law and say that we will not collect.
or they'll not raise demand. That's
Don't
it.
pay. If Odisha doesn't want to give a concession, it can certainly do it. So what is the problem in the states?
So Madhya Pradesh High Court upheld the law, no stay. Rajasthan upheld the law, no stay. Chhattisgarh upheld the law,
UP no stay.
Sorry?
UP no stay.
Which law?
What's that law?
So the point is, what I am saying is, West Bengal, Kesharam upheld, and right from 92, they have collected tax. All areas were paid fully. Heavens did not fall. No industry sunk. All these people are there in Bengal also. Use their balance sheet, etc., to show how much is that? 61,000 crore is the turnover of sale.
So Dwivedi, if we go into the states, inquiry.
The architecture.
No, I'm not saying
is different. Man.
my point is
Reasons
different.
for setting aside is
What are
different.
the provisions of those laws which are struck?
59 or 50, that also, my lord, is an issue to be considered.
I'm not requesting your lordships to go individually into the acts, not at all. What I'm saying is that look at the discrimination which will happen. West Bengal collects, other states rejected. Now we say don't collect. Best course, therefore, in the circumstances of this differential situations, your lordships in the 9 judges judgment have accepted fiscal federalism. So because of some state, etc., another state can't say. This richer state may say we will not collect. A poorer state may say money. We are not able to pay the salaries and the pensions. SLP is pending in this court for paying of pensions, brother. So ultimately, that's my bottom line, which I'm trying to convey is that please balance. It's not only their problem, it's a problem all around. So the proper balance, therefore, has to be, in my respectful submission. The first submission is that please stagger it, tackle the interest. That will reduce the burden drastically. Make it comfortable to pay. Not saying go into individual cases, but look at the situations. Some state collecting, another state, some has collected, other state could not collect because these differentials, therefore can't enter into the melting pot. Now, the other thing, is that supposing this doesn't find favor, then the other alternative which could be thought of is that right, wrong, whatever, whether it was proper or not, Kesharam made a change. Now, Kesharam basis, Bengal collected, other states make their laws, etc., which are under challenge and now to be upheld. Therefore, that can be another cutoff point. Plain and simple, do nothing and just this.
The date of Kesharam?
That is
15 January 2004.
2004.
15 January?
January 2004.
Years.
So which instead of 30 years or so, it will be 20 years.
India Cement is dated?
1990, volume 1 is
25th October
roughly
1890.
1990.
25th October 1989.
So along with that cutoff date and something tackling the interest, that is a need. And then our judgments, acts will be tested on the basis of your lordship's judgment. That's my humble submission.
So really three benefits, according to three benefits. One, stagger the payment, so delete the interest and take Kesharam as the cutoff of 15th
It can be combined or alternatively. I would put it as I'm leaving it to your lordship's.
effective levies laws of commercial improvements.
You're appearing
Yeah,
for?
just, I'm appearing in the UP matter, my lord. Facts are very startling, my lord. In the UP, the High Court has upheld the levy on 1st of March 2000 in Ramdhani Singh. In appeal in Keshoram, and in Keshoram, judgment is upheld in paragraph 134 to 148. So, my lord, so far as UP is concerned, there is no question about it. My lord, the levy is valid since beginning. Entire premise is based on that India Cement is holding the field till 4th of July 2000.
Did you raise demands and were they paid over to you? What is
My lord, two of the industries have come to your lordship. They filed a writ petition, my lord. Subsequently, they filed a transfer petition and matter remains pending. Only two, Hindalco and Kanodia, my lord, has filed the transfer petitions.
But your levy was upheld by the High Court.
Upheld by the High Court
Keswaram.
and Supreme Court specifically deals with it and upheld it.
So have
My lord, we have collected
on Hindalco and the other.
and yes, my lord,
you would have
Hindalco
collected the money.
and Kanodia Chemicals are the two persons who have been holding it, my lord. All others must have paid. Question of two industries, my lord, because they choose to file a transfer petition, get a, my lord, interim order there, ex parte, file a transfer petition, High Court proceedings remain pending, and they, my lord, they don't, and we, who said, my lord, they have not collected, now passed on. There are no facts, my lord. 142 is very important, my lord. What your lordship has said in 142, my lord, what your lords, what your, I'm so sorry. Yes. Lordship says 142, my lord, lordship would balance the equities to do complete justice in a cause or matter pending before it. They must plead and prove, my lord. A bold statement, my lord, one more thing, lord. The entire premise is based on that India Cement is holding the field. My lord, India Cement is not holding the field, my lord, since 15 January 2004. Please. January 2004, Keswaram is holding the field, my lord. Last 20 years, my lord, right, wrong, your lordship has decided. But what is holding the field is not India Cement. What is holding the field is Keswaram, my lord, from 2004. And my lord, finally, one more thing, my lord. Courts have said, my lord, Blackstone famous dictum that court finds the law and does not make it, upholding Goloknath. Retrospectivity is the rule, my lord. And my lord, prospectivity is only an exception. They must make out a case on exception, my lord. Please,
the predicament and my privilege for the state, my lords, for the state of Jharkhand, and I have not made submissions on the last occasion, my lords, because everything.
Mr. Dwivedi argued for Jharkhand.
Mr. Dwivedi is arguing.
He has appeared for the appellant, that is an authority created by me. I just wanted to point out something. I just wanted to, not more than 2 minutes.
All right.
Yes. That's two aspects which may bear consideration in regard to prospect. Is that whether the enactments pursuant to the reference having been answered would hold the field or they are struck. That is covered, my lords, that the enactments most likely would hold the field because your lordships have acknowledged the right of and the competence of the states to frame the laws. The other aspect is the molding the relief at the behest of whom? The molding the relief, your lordships have always done at the behest of the party who has successfully discharged the burden while attacking the legislation. The parties, because there is one aspect in the last order which I wanted a correction. The appellant's word used. While your lordship's appellants, we are not asking for it is the SSC companies basically.
All right.
Yes, so
That's
therefore
only a procedural order that we were listing it for today.
yes, so therefore, my lord, the other aspect which I wanted to just highlight, which your lordship have taken note of, is whether the burden has been successfully discharged by them. And then, can they ask for molding of the relief? The other,
If we close it, we'll then.
Lord,
consider
can I
that.
be, can I get, my lord, only 2 minutes? By the clock,
I want a minute, my lord, on Odisha.
Yeah.
Lord, I want to, Lord,
He has 2 more points. What is
more
the point?
points. The other is the common man effect, which my learned solicitor argued. But the money which comes to the state's coffers are also meant for the common man.
That and what else?
And third, my lords, the power to make laws and power to implement them are also in the domain of the legislature. So any of the states wants, yes.
Thank you.
And
I only
third,
want
lords,
to,
All right, let's go.
I only want a minute.
just one order which I wanted to point out, lords, because this is very crucial. The nature of the order which your lordships have passed at the interlocutory stage,
Give it to
and
us.
we have this is passed in IA number 3 and 4 in civil appeal number 4745 of 2006,
Yeah.
and this is dated 6th of December 2010. This is by a bench comprising Chief Justice, Justice Kapadia, Justice Panikar Radhakrishnan, and Justice Satwantra Kumar. May I just read the order? It's a very short order. Very short.
What is the date of the order?
The date of the order is 6/12/2010. I can pass on to the yeah. Third, learned counsel for both sides. We direct that each of the SSCs appearing before us to file returns under the relevant statute. If they have filed the returns, the assessing officer will complete the assessment by a reasoned order in accordance with law. If that order is against the SSC should prefer an appeal in accordance with law. If any matter is pending before the appellate authority in appeal, the appellate authority will decide the matter in accordance with law. It is made clear that pending appeals, every SSC will pay the taxes without prejudice to its rights and instance in the pending appeals. So these are the nature of orders which your lordships have passed.
Notwithstanding the fact that the law was struck down, those are direct.
may not be in this group itself, some, seems to be some other group.
This is from Madhya Pradesh. This is Jayaprakash Associates. No, I'm just showing the nature of interim orders. Either it has been declined or there are positive directions.
There's no such interim order for Jharkhand. That's why I got a little confused.
No, not for Jharkhand.
I only want 1 minute.
Regular bench, not in individual case, they have to take.
We'll have to bring clarity. We are not going to go statewide. We'll pass general direction.
No,
We'll bring, certainty of clarity.
In
Well, I only
The other we'll.
I only wish to say one thing.
There is only
What?
Now, Mr. Ansariya, you have.
Lord, what Mr. Dwivedi is saying for his state relating to mineral bearing areas, that cannot be the rule otherwise. Without Odisha is only mineral bearing. Our act was struck down in 8 months. Not a single demand was raised. There was no levy. I did not collect. I did not pass on. So after 30 years or 20 years, to put this burden today, that I will not take it, pass it on to somebody else who has consumed it. How will this principle apply?
Who are you appearing from?
Not for the Odisha industries. We are Odisha industries. There was never a demand, and when the government lost and came to the Supreme Court, there was no stay in the SLP of the state of Odisha. No stay at all. Not below half stay, will say. In the case of Odisha, my lord, demand not raised, act struck down in 8 months. No demand, no levy, no pass on. And no stay in Supreme Court. If this be the position, how can, my lord, we be bulked, my lord, with these demands today to be, which we can't recover from anybody? And today, if I pass on to a new consumer, it will be a double whammy for him. Because either the new
Yes,
Well, only 2 minutes. Well,
One
it's
sentence
nobody.
and I'm over. One
that-
sentence. Well, there are 6 matters from Jharkhand High Court, Patna and Jharkhand. 3 decided pre-Keshav, one way. 3 decided post-Keshav, other. That's all I'm.
My lord, only one thing, my lord. The conundrum which Mr. Dwivedi tried to create, my lord, which will be the law which will govern. We are clear, your lordship's 9 bench judgment holds the field, India Cement goes. Nobody says that previous to your lordship's judgment, the India Cement ratio should remain. Lord, whether we use the expression prospective overruling or not, we are urging your lordship's 142 power to mold the relief in peculiar facts of the case, that this is not A versus B litigation, but the result will be felt by each and every common man of the country. So that is why your lordship's power of 142 to mold the relief comes. Lord, so far as this distinction between principal and interest, without again naming the PSU, without interest, of the major PSU has 35,000 crores without interest, only the principal, and its net worth is 14,000. Net worth is 14,000, and the demand without interest is 35,000. Since it's a listed company, I am not naming the company. I can, my lord, share it with your lordships. My lord, even if your lordships may be persuaded to...
Now the demand of 35,000 crores, how much of it is principal and how much of it is...
Only principal. My lord, with interest it is 55, but only principal without interest is 35,000. Therefore, I gave this figure, that this is not the figure inclusive of the interest, and the total net worth is 14,000. Now, my lord, even if we were to stagger and pass it on to the end consumer, ultimately the end consumer will be burdened, my lord. So we are not saying, my lord, that till your lordships have decided, let India Cement hold the field. That's not the argument. India Cement goes. Your lordship's judgment is the only judgment which is the law of the land. Your lordships can mold the relief that in Calcutta, miners have paid, mineral my lord, bearing land, they have paid. In my lord, they have paid. Orissa, they have not paid. Therefore, my lord, I have said that taking a broader picture, since, my lord, it is a constitutional issue which your lordship settled now, that let there be a pan-India decision that now, hence, my lord, many a state where the demand, my lord, the act was sustained by the High Court, upheld the demand, upheld the law, but the demands were not raised. So there was no payment. Wherever demand was raised, there is a payment. So
It could be the liability. I think it would be difficult for you to answer us offhand. If we take the cutoff as the date of the Kesaram judgment.
my lord, 20 years
No, it is more than 1,50,000 crores from 2004.
for private industry.
Yes. I've got figures of a large private company I'm appearing, but I don't want to disclose it now. But it is in excess of 1 lakh crores.
Yes.
Lord, the further difficulty is this. The Lordship has now upheld the power under entry 14 and entry 50. Your Lordship has said state has got full power under 14 and plenary power. 50 subject to what limitation? Now, today from 25th July, Lordships have held in Rai Ramakrishna, tax laws can be retrospective. There's no difficulty. Just envisage different states. Let us not go state by state. Suppose tomorrow every state has endless amount of money. It's insatiable because with the kind of commitments they have. Tomorrow, from 1st August, the state pass a law. You will pay retrospectively from 2020. Somebody will say from 2015. Then again,
If someone says it-
2004 is also 20 years burden.
Well, the point is,
Let's not go into the niceties or academic discussion.
we are going to go
2004 is also, my lord, 20 years burden. My lord, and between 2004 to 2024, Lord, there will be several financial transactions which must have
One
taken
more
place.
thing.
What your lordship weighs?
You of Kesharam. But was it correct for Kesharam to take not that kind of view to explain 7? Is that another issue?
Okay, should we close it?
5,
Heard everybody.
11,
no, my lord, just-
5, 7, explaining 11. We have this problem, my lord, it can never be.
My lord, can I just,
My lord, explained by 5.
my lord, can I just suggest two tests, my lord? My lord, can I just suggest two tests, my lord? Yes, my lord, can I just say two tests? Just two tests, yes.
So I think we've now.
Yes, yes. No, my lord, your lordship,
Lordships have
when your lordships are.
142, that,
One last-
lordship's,
last
my
two
lord,
tests.
desire to do complete justice is the test. My lord, there is no other.
Yeah.
Yes.
Yeah, absolutely.
Last two tests, lordship, when your lordships are discussing, please visualize what is the extent of disruption your judgment will cause because if it goes retrospective. And secondly, will it create liabilities which did not exist on 25/7? In some states there are states, but in most of the states there is no law at all. Except barring couple of states, UP and Rajasthan, my Jharkhand, in most states there is no law.
Like my
And-
state, if there
and
was
my lord, please
no
don't
Just to visualize, will your lordship
me
judgment,
to pay for something when
And-
there is no law.
or the two tests, Lord,
And-
Survey comes in.
And please
What
don't
is the
give
test of
states
disruption?
like retrospective legislation.
If the states, if your lordship judgment is going to enable states to create liability, it will be a retrospective liability. So my humble submission is, let it be a binary, not black and white. Let it be prospective. Royalty is not a tax from 25/7. Before that, whatever it was,
No,
finished.
we are
Yeah.
not on
Get
royalty,
that, yeah.
tax, etc.
Again, you want-
Levies.
Attention, you have a turn of phrase as we rise. Not a submission, but a turn of Attorney General's phrase.
Whatever one may say, we are talking about judicial retroactivity.
No,
And you'll also have to manage that.
I think we heard everybody.
Grateful.
I don't think anybody will have a feeling that we didn't.
Lord,
get-
All I said, all I
Never
am saying
have
is
that.
please don't give states ideas like retrospective legislation.
The last word which I gave the Attorney General on the bench, I give the last word to my brother Justice Rishikesh Roy as usual.
Yeah, yes, ma'am, we are also eagerly waiting.
Yes, certainly.
And my lord, one last thing, my lord, the judgments are more difficult to
God.
change because
Enough now.
law we can challenge, but a 9-judge judgment we cannot touch at all. Many years.
Enough.
Oak said leave something for our future, so we can have. But justice, my lord.
What I could understand, very strong battles fought. And the expression used is from this side is that no refund, no demand. It reminds me of a similar war, but in a martial art field. No retreat, no surrender.
Yes. That is balancing equities, my lord.
Very grateful, very grateful.
Please have orders and pronounce your.
Very grateful.